I ask you, Ms. Rasmussen, when you get a sample to be tested, who tells you what area, in this case, so there's a firearm, right? You test?
The DNA unit did not receive the firearm itself in this case.
What did you receive?
We received swabs that were collected from a firearm.
Okay. And so when law enforcement sends those to you, they tell you this swab was taken from this area of the firearm or this area of the firearm, and we'd like you to test it. Is that right?
Yes.
Okay. Would you agree that you never got a swab from the barrel of that gun?
The barrel guard was the closest, to my knowledge, that was obtained from the barrel of the gun.
Do you know what a barrel guard is?
I do not.
Okay. You'd agree, however, it's listed barrel guard. There's nothing on here listing barrel of gun.
Correct.
Okay. So if, for example, Joseph Rosenbaum touched the barrel of that gun, we'll never know that, right?
I have no way of determining it.
Because it wasn't sent to you for analysis, right?
Yes.
Now, Jim. Mr. Rasmussen, I'm going to show you what has been marked exhibits 45 and 46 for identification. I just would like if you can tell me what you see in those exhibits.
In Exhibit 45, I see a person walking the opposite direction of whoever's taking the photo, and a person on the ground, and there's an object connecting them. The person on the ground appears to be holding on to the object.
Okay. Jim, can you tell me the object? No disagreement that the person on the ground is Mr. Rittenhouse? No disagreement that the person standing up is Mr. Huber?
No disagreement.
No disagreement that the object in between them is a firearm?
No disagreement.
Okay. So, Ms. Rasmussen, if I told you that person standing there is Anthony Huber, okay, that we agree on that, you agree that it appears Anthony Huber is touching that, and we agree that's a gun. You'd agree that Anthony Huber is touching that gun, right? Appears to be he's touching that gun?
It appears to be.
Okay. Now, in the areas, so the fact there's no DNA present in the areas you were asked to look at doesn't mean that the person didn't actually touch the firearm. We see it, right?
Correct.
Okay.
The DNA, yeah, correct.
Okay. Can you do the other one, please? So if I told you that's a different angle, that's Mr. Rittenhouse on the ground, that's Mr. Huber holding the skateboard, and that's a firearm, you'd agree it appears that Mr. Huber is touching that firearm. Would you agree with that?
That appears to be the case.
Okay. And so the fact that, I don't know where that is on the gun, but the fact that the DNA isn't there, and everybody thinks DNA is this thing that proves everything, you'd agree that we can see he's actually touching the firearm.
What is your question?
Well, the fact that it's not present, and I don't know where on the gun that is, but the fact that DNA is not present in any of the areas of the firearm for Mr. Huber doesn't mean that he didn't actually touch it.
Correct. Whether DNA was detected from an individual or not does not mean that they did not touch that item.
And I think you said, and tell me if I have this right, the shorter amount of time someone touches something, the less likely there'll be DNA which you can compare or find.
Yes, the less an item is handled, the less I would expect there to be an opportunity for DNA to transfer.
Was there ever a follow-up request by law enforcement to test any other areas of that gun?
Not to my knowledge. That may not have gone directly to me, though it may have been to someone else at the crime laboratory.
Your Honor, I'm sorry, I don't remember the numbers. I'd move 40, is it 45 and 46? Ma'am?
Yes.
I'd move 45 and 46, if there's no objection.
No.
Steve,
And I have no other questions. Thank you for your time, ma'am.
any redirect?
No.
Let me step down, ma'am. I haven't heard anything about food, so we'll just keep. Mr. Mayor?
Would you like me to leave this here?
Yeah, well, here,
We have it digitally that will submit.
okay. Although actually, unless you need it, well, go ahead, do it.
No, you can have it. We have
No.
1,000 copies of it if you want it.
Let's fight over it.
Shall we continue?
Please.
Is there called Susan Hughes' name?
What was that? Just push that mic aside. Yeah.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, could you please state and spell your name for the benefit of the court reporter?
Susan Hughes, Hughes.
Ms. Hughes, did you know Anthony Huber?
Yes,
How did you know him?
I am his great aunt.
And,
His grandmother was my oldest sister.
and how did you come to know Anthony?
Well, my niece is his mother.
So did you know him from when he was a child?
Yes.
And would you have considered yourself close to Mr. Huber?
Yeah, even when he was a child, we had kind of a special connection. But I was born in Kenosha. I moved away, came back in 2011, and from that time, we became even closer.
Now, you said you had a special connection. What do you mean by that?
He was a redhead. I used to be a redhead. He was, his immediate family, they were all blondes. So he kind of gravitated to me at family gatherings and things. even though when he was a child, I really only saw him, holidays and when I visited Kenosha, so, 4 or 5 times a year. But even then, he would gravitate towards me because I could talk to him about things he was interested in. I mean, we shared interest in art and music and computers, Star Wars, things that little boys like to talk about.
So you said you would see him in Kenosha. Did Anthony grow up in Kenosha?
Yes, he was born here and went to school here.
Do you know if you know any schools he attended here?
Well, he's in the Southport neighborhood, so I think he went there perhaps. I know he was at St. Mark's for a while. And I don't know, would those kids go to Lance maybe for middle school? I'm not sure.
Norm?
I was living in Madison, so I wasn't real connected to what schools he was going to.
So in 2011, you said you moved back to the Kenosha area,
Yes.
and you said you became more close. What do you mean by that?
Well, from that point, I moved back because I had health issues and both of my sisters did, so I was seeing his grandmother quite frequently. And Anthony was very close to his grandmother, so, I would see him sometimes, once or twice a week. He would call her frequently. Yeah, she moved in with me, actually, in 2013, and from that point, we saw Anthony even more. He frequently needed rides to jobs and things, and when she wasn't able to take him, I would take him.
And about how old would Anthony be in this time period?
Well, when I moved
Teenager,
back,
adult?
I think he was like 17, maybe, when I moved back here.
And even back then, did you ever know Anthony Huber to use a skateboard?
Always, always. The skateboard, I must confess, was kind of an annoyance to me because he would, when I first moved back here in 2011, we had a family gathering. We had a dinner in the winter, and I lived close to Penoyer Park. And Anthony arrived in a car. There was a foot of snow on the ground. He walked into my house with a skateboard and was gonna, skate on my laminated floors. And I said, "You can't skate in the house, and where are you gonna skate anyway? Because there's snow on the ground." And he, picked up his skateboard, he went out and he found a place to skate in the snow. I mean, he always, even shortly before he died, when I would take him somewhere, he would know I was picking him up in a car, he was gonna go home in a car, he would still have the skateboard in case there was a chance, there was an interesting parking lot somewhere, and he could go out and skate.
To the best of your knowledge, was that his main mode of transportation if he wasn't getting rides from
Yes.
you or someone else?
Yes, he skated sometimes to jobs if I wasn't available to take him there, or one of his friends. He would skate home frequently, quite long distances. Some of the temp jobs that he had were out by Jelly Belly and out by I-94, and if people don't know where that is. Anton's, that's like Cooper Road or something. And so miles he would go on a skateboard.
And was this a hobby of his? Would he compete in skateboarding events to the extent you know?
That I don't know. I was a sometimes supporter of his habit.
Okay.
So, he would talk to me a lot about it. He would send me videos and things, but I really didn't follow whether he was competing. I know when he was younger, meaning, 18, 19, he was actively looking for sponsors and things. I mean, that was something he was interested in, but that never materialized.
Now, were you finished? I'm sorry.
Oh, and I know that as he got older, one of his pipe dreams he had told me was that he wanted he had a vision for an indoor skate park downtown Kenosha. And, you know,
So skateboarding was central to his character, is that fair to
yes,
say?
yes.
Now, I'd like to draw your attention or bring you to late August of 2020. Were you living in Kenosha at that time?
Yes,
And are you aware of the shooting of Jacob Blake and the events that followed that shooting?
yes.
And during that time frame, did Mr. Huber contact you?
Yes.
And when's the first time did you guys have like daily contact, or how did this come about?
Well, that whole weekend, you know, a few days before and then certainly after Jacob was shot, we had frequent contact during that period.
And did Mr. Huber have any special interest in the Jacob Blake shooting or the events that followed?
Yes.
And what was that special interest?
He told me that he knew Jacob. We had, Anthony would sometimes want to go with me out to Petrifying Springs. There's a memorial bench there that is dedicated to my son who
Right.
passed away. And after Jacob was shot, Anthony wanted to go out there with me. And while we were there, he told me he had known Jacob. I frankly don't recall how well he knew him. I mean, it just sticks in my memory that he said he knew him. That was the reason why we went out that day. He knew that Jacob had children. He knew, you know, I remember him mentioning a few things about Jacob's life.
Let me ask you a question.
Sure.
Did you know Jacob Blake?
I did not.
Now, so what day did you go to this, you said a memorial bench for your son?
Mm-hmm.
And was that someone that Anthony Huber was close to?
Yes.
And what day did you go to this memorial bench?
I believe it was Monday.
And that's when he told you about, that he knew Jacob Blake, and you
Yeah.
discussed his feelings about the protests and all that?
Yes.
Do you know if he had gone out on any on any night to engage in a protest?
I know he had gone, he had taken his phone. He told me he was just wanting to take some videos.
Now, it's been established that Anthony died on the late night of August 25th. Did you see him anytime that day?
Yes.
Why did you see him?
He stopped with Hannah late in the afternoon, maybe 3:30, 4 o'clock. They were on their way to do a lot of errands, and he stopped to, I think, I gave him some mail, and he was on his way to a cell phone store. I gave him some cash because he needed to resolve some things with his cell phone.
Now, is this something that you would do? Would you occasionally give him money?
Mm-hmm.
And did he have a driver's license? Did he know how to drive?
Yeah, he got his driver's license the day of his birthday, the Friday before.
Okay. And who would go practice driving with him and things of that nature?
That was me.
You mentioned a Hannah. Who's Hannah?
Hannah was his girlfriend.
So, do you recall approximately what time of day that you saw Anthony that on August 25th?
Like I said, I think 3:30, 4 o'clock. I remember it being later in the afternoon because we had a conversation about the traffic, and I reminded him he needed to get back in town before curfew.
And then with that, did they depart?
Yeah.
And was
Well,
Hannah,
no, excuse me. Was that the, can you repeat that question?
Then they left after you said be back by curfew? Is that then
Yeah,
they left to go
yeah.
to the store?
Yeah.
Or wherever they went? Was Hannah driving at that point?
I think it was Hannah's car, but Anthony was driving.
Now, we've seen video here, and you may have seen video as well, that Anthony Huber ran towards Kyle Rittenhouse. Well, Kyle Rittenhouse was armed. Were you surprised, when you heard about that, were you surprised by his actions? Had you ever seen Anthony Huber run towards danger?
Yes.
Sustained.
As to which ground?
Both. Well, maybe, certainly on the second ground. Habit or custom,
We've heard nothing but having a custom evidence in this case.
pardon me?
We've heard nothing but having a custom evidence. I think I can rehabilitate.
Well, first off, you don't need to comment on the ruling. Secondly, they're different rules. And we've been talking about this all along. There are different rules. Let's take a break. Please don't talk about the case. Lunch is here. And read, watch, or listen to any account of the trial. And we'll aim for about 12:30. Pardon me? What do you want to say, Mr. Kraus?
Judge. Judge, I'd like to direct your attention to 90404 sub B. The character of the victim, offered by an accused or by prosecution to rebut the same, or evidence of a character trait of peacefulness of the victim, offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. We are rebutting the evidence and characterization that's been made both in opening statements and in cross-examination that Anthony Huber was attacking, being the aggressor against Kyle Rittenhouse for seemingly no reason. This is what the defense says.
Do you want to respond?
Well, the response is there's been evidence that Mr. Huber, while Mr. Rittenhouse was on the ground, struck him in the head with a skateboard. So I think that goes to, if I can here, I don't know if that rebuts evidence that the victim was the aggressor when it's really just a fact on video that in fact he did strike him in the head with a skateboard prior to being, and then grabbed his weapon prior to being shot. So I guess the court has to make a determination whether or not the evidence that's been put into the record up to this point would support the idea that we're just saying watch the video, which clearly shows what Mr. Huber had done to, I think it goes, Mr. Rosenbaum was, I think the question is we've alleged that he's the aggressor here. Mr. Huber, his acts speak for themselves in terms of what he did.
So you're indicating that Anthony Huber was not an aggressor?
I'm saying that the evidence shows that Anthony Huber swung a skateboard at the defendant's head. Then he hit him in the back of the head with a skateboard while he was lying on the ground. then he grabbed his firearm. That's what I'm alleging.
I guess what I guess what I'm struggling with, oh, did you want to say something?
Yes, that's precisely why we have this.
I'm sorry, I didn't hear you.
This is precisely why this rule is here. They are alleging that Anthony Huber attempted to strike Kyle-Rittenhouse with a skateboard, missed, and then came and we would say did not strike him with the skateboard, perhaps attempted to strike, but came at him with the skateboard and grabbed the weapon. They are calling him the first aggressor, although now they're apparently not. So we can rebut that evidence, and our theory, as we've laid out, is that these people were going to stop an active shooter, that they were provoked by Kyle Rittenhouse, by his actions with Mr. Rosenbaum, that his actions there were of such provocation as they believed he was an active shooter, he was a danger to all of them. The state frankly believes that Mr. Huber is a hero, and that we can present evidence of conduct to rebut this claim that he is aggressively pursuing Kyle Rittenhouse with no basis, which is exactly what they're saying. Mr. Trofsky just laid out the evidence that they have called Mr. Huber the first aggressor against Mr. Rittenhouse.
Okay.
We can rebut that.
Okay. With respect to Mr. Rosenbaum, the defense has definitely suggested and presented evidence that Mr. Rosenbaum was a turbulent personality and was acting in an aggressive manner, and that is certainly a pertinent trait of character in terms of the question as to who was the first aggressor in the incident between them. I didn't hear a similar attack on Mr. Huber, as I think Mr. Sharafi has just stated. What the defense has offered with respect to Mr. Sharafi is direct evidence that Mr. Huber did actions that the jury actually has the unique benefit in this case that we wouldn't see in 1 in 100 cases, or even that, where they can actually see the action. So the evidence that you're offering now is character type evidence, which is really not directly rebutting the physical acts which the jury has been able to observe, as opposed to the case of the Rosenbaum evidence, where they've not seen the act and there was evidence introduced as to turbulent character. So it's rebuttive. Is that a word, rebuttive?
I don't believe so.
Well, let's call it rebuttalistic. I asked to the.
I think that's twice now the word.
But you know what I'm going to do? I'm going to think about it during the break and read what Judge Weinstein and other commentators have to say. And then it's an interesting point. But my initial suspicion is that this doesn't rebut with the acts which the jury is able to see, because and the statute makes reference to and offered by the prosecution. Where is it here? Offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor.
That's precisely what they presented. If they want to stipulate that Mr. Huber was not the first aggressor in terms of his interaction with Mr. Rittenhouse, I think we'll gladly accept that stipulation.
What did they show? What has the defense offered?
In the opening,
In argument or in either an argument here during the case or an opening or in the evidence, what did they offer on the subject of aggression by Mr. Huber other than the act with respect to the skateboard and any effort he may have made to de-weaponize the accused?
in terms, all we know, and I can be corrected if I'm wrong, the only interaction that I'm aware of between Mr. Huber and Mr. Rittenhouse that night, there may be some pictures where they're sort of seen in close proximity, but the only interaction that I'm aware of between the two is you see Mr. Huber, I believe this was an opening, sort of focuses attention on Mr. Rittenhouse, begin running that way. He either swings and loses his grip on the skateboard or throws the skateboard at Mr. Rittenhouse. It goes to the other side of the road. He then goes and retrieves the skateboard and then goes back towards Mr. Rittenhouse. So I don't see how that is not the defense calling him the first aggressor. It doesn't have to go back all through the night like they've been allowed to do with Mr. Rosenbaum. They are saying, unless they are agreeing that Mr. Rittenhouse was the first aggressor, they're saying he was the first aggressor by throwing a skateboard at him and trying to hit him with a skateboard.
Okay?
So we can rebut that. According to the statute. It's plain language in the statute.
Well, I'm gonna see what the commentaries say. We'll take a look. Why don't you come back about 12:25 if you can? Oh, all right, 12:30. 12:30. Aren't you a light eater like me?
Judge, do you mind if I take this out of your courtroom?
You may take it, yeah, as long as you promise to return it.
Well, of course.
We're gonna, 12:30.
That's real time.
Yeah, you got it. So you got about 33, isn't it? All right. As there is before, jury's not here. And I did, does anybody want to speak further on this?
I just wanted to let the court know what we're getting
Mr.
into.
Mayor's not here, do you want to wait or?
No,
or-
he's given me permission to drive the
Okay,
car.
all right, go ahead.
So just so the court knows where we're going, and it may or may not impact the ruling, we're going to be talking about a specific incident when Mr. Huber was a child in which he ran to try to help stop an explosion at a family gathering. That's what we're getting into. And it's not a general, he was a good guy kind of thing. It's a specific act to rebut that Anthony Huber was going to attack Kyle-Rittenhouse. We see it more as he was going to try and save people from Kyle-Rittenhouse. That's our basis, and I just want you to know where we're going. Legally, I think that's permitted.
Okay, defense?
Excuse me, Judge, I would argue that's not a character trait for peacefulness, first of all. But if it comes in, then I'm going to ask the court under 90405 to allow specific instances to rebut that, which is allowed under 90405 sub 1. I have 2 criminal complaints involving Mr. Huber where he caused physical harm to other people. And I think if they're going to lay forth or try to lay forth opinion evidence on peacefulness, 90405 allows me to rebut that on cross-examination with specific instances of conduct. But overall, I don't think running to something is a character trait for peacefulness, in my opinion. So that's what I would ask the court to consider.
Okay, well, I looked in the books. And Colonel McCormick section, and this, we don't update a lot of these things anymore. This is from 1990. The laws of evidence don't change that fast, although there's been change to this rule fairly recent. And I actually, one of the issues I didn't get to yet, and may not have to, is whether on the particular points we're going to talk about, whether the federal and Wisconsin rules are alike, because there's been somewhat of a change. But this is from 1992, and it's section 193, Colonel McCormick, a well-established exception to the rule forbidding character evidence to prove conduct applies to homicide and assault cases in which there is a dispute as to who was the first aggressor. This exception permits the accused in such cases to introduce appropriate evidence of the victim's character for turbulence and violence. In response, the prosecution may adduce evidence that the victim was a characteristically peaceful person. So it says that the accused can offer evidence of the defendant's character, of Mr. Huber's character for turbulence and violence. They haven't done that. They've introduced evidence of specific acts of Mr. Huber. And that sentence, the second sentence I read, is in response, the prosecution may adduce evidence that the victim was characteristically a peaceful person. So you're responding to something that hasn't been offered, which is character evidence about Mr. Huber. Now, if I read to the revision from 1974 of the federal rule, evidence of a pertinent trait of character of the victim of the crime offered by the accused or by the prosecution to rebut the same. And again, rebut would be in reference to the evidence of a pertinent trait of character, which has not been offered by the defense. Or character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the defendant was the first aggressor. So it says evidence, it doesn't say character. So that second phrase seems to suggest that the prosecution can offer evidence in a homicide case to rebut evidence that the defendant was the first aggressor. Wait a minute. Let me look at that again. And respond. Or evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the defendant was the first aggressor. So,
Are you reading that right, Judge?
I hope so, because I read it the first time and I questioned whether I had. Let's see. Or evidence of the character trait of peacefulness of Mr. Huber offered by the state in a homicide case to rebut evidence that Mr. Rittenhouse was the first aggressor.
I have victim was the first aggressor.
Well, I'm reading from, and I'll try one more time. Here, wait.
It's victim.
Wait. What?
We agree that victim was the first aggressor.
And I'm going to offer as an exhibit here, just to say that my eyes are not failing that badly. You can look at it yourself. It says defendant. So much for that book. You can look at it yourself. It's there. All right. No wonder we didn't renew that book. You could make a big mistake with that. Let's read from my favorite, which is Judge Weinstein, who says, and this is at 7013C that we've talked about before. When the defendant offers evidence of the alleged victim's character, then the prosecution is entitled not only to offer rebutting evidence about the victim's character, but also introduce evidence that the defendant has the same character trait. So it starts off when the defendant offers evidence of the alleged victim's character, which hasn't been done.
That's the first part of that statute, not the second.
Well, the second part, if we're talking about this, I'm talking about 2B, which is going to be one, when they do these transpositions of the numbers. What are you offering it under? You tell me the statute you're offering it under.
I'm
I
offering
thought it was 1B.
90404 1B, but there's two provisions in there.
I know there are.
Okay, we're talking about the second, which is the character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor.
Right. And that is a more sweeping statement than the older material before, I think it's a 1974 revision. Anyway, there was disagreement in the other one I used was the Graham Handbook of Federal Evidence, and there's disagreement. So when I walked out here, I thought, well, I think I'm going to resolve it, the tie in favor of the state. Now, you're forewarning them that you have got some other crimes or some contrary evidence, I guess rebutting evidence that we might as well talk about now rather than have to excuse the jury again. Are you prepared for what the defense suggests they're going to offer?
Yes, I don't believe the incident in which an individual runs to try to help or try to save people brings in completely irrelevant criminal acts that have already been barred.
It's character traits for peacefulness is what they're getting into. I have 2 criminal complaints, one of which the defendant held a knife to his brother's throat. He put a knife to his brother's ear. He called him, he said he would gut him like a.
You said what?
Mr. Huber told his brother that if he didn't start cleaning a room in their house, he was gonna gut him like a pig. Mr. Huber's brother noticed a knife in Mr. Huber's right hand that looked like a butcher knife, 6 inches long with a green handle. Mr. Huber later on in the same incident threw a chair and some clothes across the room, threatening to kill his brother if he didn't clean. Mr. Huber then sat down with the knife in his hand and watched them while his brother and Mr. Huber made his grandmother pick things up as well. And Mr. Huber told his brother that if he stopped cleaning, he would kill him. Mr. Huber's brother then turned around and Mr. Huber put a knife to his brother's stomach, saying he was going to gut him like a pig. Mr. Huber's brother bent down to try to protect himself. Mr. Huber then grabbed his brother by the neck, dug his nails in, and choked him for approximately 10 seconds. He then put a knife to his brother's left ear. His brother felt the blade and believed his ear was cut. And then as he left, he told the people in the house, "I'm going to burn the house down with all you fuckers in it." That's what Mr. Huber had said in that instance. And that is charged in Kenosha County case 12 CF 1346. He has another criminal.
What was the outcome and when 12 CF?
12 CF 1346. I believe he entered a plea to strangulation and suffocation in that case.
Okay.
I have a 18 CM 509 case in which he kicked what I believe is his sister, Caitlin Hughes, in the right hip, causing her pain and causing her to fall into a nearby dog crate. So I would normally not move to admit those. However, if they're saying that this is a peaceful man, and if you say, Judge, running to this area to stop whatever was happening, it's not a fight or there's no violence, it doesn't sound like. But if you're saying that's peaceful, 90405 allows me to get into specific instances on cross.
I know that.
So,
Can I respond? I believe 90405.
Could you start over?
Sure. I believe 90405 allows specific instances of conduct of the individual being cross-examined, which we obviously cannot do. This I don't know how they would get this in. I guess.
Wait a minute, what do you mean? What do you can't agree? The individual being cross-examined will be the person who's giving the opinion. I tried this case, State against King, right here in this room when I was district attorney, 1974, 75. Mr. King shot his wife in the eye and killed her, and there was testimony. Well, the bottom line was that I was allowed, when the an opinion had been expressed about the character for peacefulness of the accused, and on cross-examination, I inquired, would your opinion change if you knew thus and so about Mr. King? And there was objection because it was a specific instance, and the Supreme Court said that was permissible inquiry because the opinion had been rendered, and the wealth of knowledge of the opinion giver was therefore subject to scrutiny as to how much information this person actually knew, because the character you're trying to present isn't limited to just an incident involving a fire at some point in time, but is limited to the entire character of the decedent. So my initial inclination would be this is probably admissible. Probably. And if you go ahead with the evidence, and you're welcome to do so, although the defense has also pointed out correctly that the character is for peaceableness, and what you were talking about was more heroism. So, but I think I'll give you that much. But you're forewarned. I'm going to be taking another look at that King case because it's been a long time. But this sounds like something that he'll be allowed to go into.
Understand?
What do you want to do?
I will not submit the evidence.
You what?
I will withdraw that question and not submit the evidence.
You'll withdraw that question and?
I'm not going to elicit that testimony.
Okay, do you want Mrs. Hughes back on the stand?
Yes, there's still just a couple
Okay.
more questions. They obviously have to cross-examine her.
Okay. Are we ready for the jury? Would you come down, please?
Yes.
Mr. Schroff, see what?
Just putting your book back. I want to witness.
Good afternoon, everybody. We had some additional discussion on the issues that were pending, and it has been decided the state has decided to withdraw the question which was asked.
Settled in? Okay. Ms. Hughes, the night of August 25th, or into the morning of August 26th, when or how did you hear about what had happened to Anthony?
I got a text around midnight, maybe a little after, from Anthony's girlfriend Hannah, saying,
Oh, we don't need to get into the context of it. That would be
Okay.
called hearsay. And then, did you ever receive any further communication about? Let me ask it this way: when did you find out that he had died?
much later. It was maybe 5:30 in the morning.
And how old was Anthony when he died?
He had turned 26 a couple days before.
Ma'am, I'd like you to look at there's an item in front of you which I've turned over. I'd ask you to turn it over to look at it. It's marked as States Exhibit 44. Do you recognize that?
Yes.
What is that?
This is a photo of Anthony as an adult and Anthony as a child with his skateboard.
And are those pictures you provided to my office?
Yes.
Are those true and accurate copies of how Anthony looked at in childhood and as an adult? I'd ask that Exhibit 44 be entered into evidence and published to the jury by being passed around.
Is there objection?
There is not.
Okay, go ahead.
That's all the questions I have. I'll give it over.
And he can do it.
I'll do it.
Yeah, thank you. Did you have questions?
I have no questions for Ms. Hughes.
Okay, thank you, ma'am. You may step down.
Thank you.
Carry on.
Oh,
Oh. So,
would you raise your hand, please? Do you solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please be seated.
ma'am, could you please state your first and last name and spell them for the benefit of the court reporter?
Carrie Ann Swart, it's spelled K-A-R-I-A-N-N-S-W-A-R-T.
And Ms. Swart, do you know Joseph Rosenbaum?
I do.
How do you know Mr. Rosenbaum?
He's my fiance?
And is Mr. Rosenbaum still living?
No.
And did he die on August 25th, 2020?
His date of death is considered August 26th.
And before that date, how long had you known Mr. Rosenbaum?
Since August 3rd of 2019.
And after you met, how long did it take till you started a romantic relationship?
About maybe 3 days.
And had you known him before? You never met him before August 3rd?
No.
And where are you from?
I grew up in Illinois.
What would you and Joseph do together?
When Joseph and I were together at the beginning, we were homeless. We just spent a lot of time talking, getting to know one another, and laughing and joking around. He was a very animated person like that.
And is Joseph from Kenosha?
No, he is from Waco, Texas.
And do you know why he moved up here?
He moved up here to be with his girlfriend at the time and their child.
So does he has a child living in Kenosha?
Correct.
I would like to bring your attention to the day of August 25th, 2020. Did you see Joseph on that day?
I did.
And where did you see Joseph?
I saw him at the motel that we were living at,
Was it in the motel or outside the motel?
outside the motel.
And had you seen, do you know where Joseph had been in the days prior to that?
Correct.
I'm sorry. Do you know where he had been in the days prior to August 25th? In the day or two prior?
Yes.
Where was he?
He was at a hospital in Milwaukee.
And do you know for sure how he got from the hospital in Milwaukee to back to Kenosha?
I am not 1,000% sure. As far as I gathered from him and from the hospital, they brought him down here.
You didn't bring him back down.
No, I did not.
And he wasn't dropped off at this motel?
No.
So how did, if you know, how did Joseph, do you know where he was dropped off?
I believe he was dropped off by the transit center.
So right around here in downtown Kenosha? And do you know how he got to your hotel?
He walked.
I don't want to give the name because it's, about how far would that be?
About an hour, 40 minutes, 40 minutes to an hour, I would say.
So the hotel is not in downtown
No,
Kenosha?
it's not.
Ma'am, can you bring the microphone a little closer? It's kind of hard to hear in here.
Is that better?
And when Joseph arrived at your hotel, what did he have on him?
You mean as in on his person?
Well, let me ask this way. What was he wearing?
He was wearing jean shorts, white shoes, and a red top.
Did he have a bandana with him at all?
No.
And was he carrying or holding anything?
He was carrying a plastic hospital bag.
And did you see the plastic hospital bag?
I did.
Did you see what was inside the plastic hospital bag?
I did.
What was inside the plastic hospital bag?
I saw socks, a miniature deodorant, like trial size, little toothbrush and toothpaste, paperwork, and an empty water bottle, like a plastic water bottle that was empty.
So when you're talking about a plastic water bottle, let me just borrow
Yeah.
one from the detective here.
Yeah.
Do you mean like your standard 16 to 20 ounce plastic bottle, or like something you'd see maybe at a gym or on a bike, like a more heavy plastic?
No, it was a plastic bottle like that.
So a small, probably 16 ounce plastic.
It was
water bottle.
empty. There was no water.
And did you talk to him about this bag?
I did. I just asked him if he wanted me to throw it out, and he had said no, he was going to carry it around with him because of the few items that were in it.
About what time did he arrive at this, or I guess near this hotel?
I would say between 3:30 and 4:30.
And what did you guys do once he arrived?
We talked. We hadn't seen each other for maybe a week, and we just mostly talked about his and my relationship.
And this was outside?
Correct.
And then actually, let me ask it this way. Do you know if he was able to procure any medication that day?
He was not able to fill the prescriptions he had because the Walgreens closest to us had been boarded up and closed down due to the chaos that was going on.
Do you know, if he had taken his medications that day?
He had.
Who have the TVs on? Ms. Swear, I'd like to show you what is marked as Exhibit 26. Do you recognize that?
I do.
And what is that?
That is the plastic bag from the hospital.
And is it true that a few days ago I showed you a printout of this exact exhibit?
Yes.
And is that the plastic bag that you're referring to that he brought back from the hospital?
Yeah, it's like one of those plastic bags that you just put your clothes and belongings in.
And in looking at the screen, does it seem like there's more items or fewer items or the same items, if you can tell, that he had when he was at your residence?
It appears to be the same as when I saw it.
Can you make out anything in this photograph?
I can make out. I think he might have had an extra shirt in there, that might be, and it looks like the water bottle on the side. Shirt.
Sure, thank you.
Do you know if Joseph Rosenbaum knew anyone named Kelly or Joshua Zeminski?
He did not.
Sustained. Expect the answer. The witness would not be in a position to know the identity of all persons that the accused would have known, the decedent would have known. Thank you.
Do you know if he knew any people in Kenosha?
No, he did not.
Same objection. Not sure I heard the question.
The question was, do you know whether he knew many people in Kenosha? And she answered, pardon me?
That would be my objection would be the same.
Okay. It's along, generally, it's the same, would be the same ruling, except that it's like my asking if you know people in, many people in Topeka. That's really a bad example, you know. But the bottom line is, it's a little bit different from the last. Did the decedent know an individual, a specific individual? Now he's asking her, did he know many people in Kenosha? And I think that she'd be in a better position to answer that, so I'm going to let that one go.
And you said no?
Correct.
Now, in your relationship, this about year, how often were you with him?
Every day.
And were there times he would go out on his own?
No,
Were you together all the time?
all the time.
And you said for a while you were homeless, and you said you were living in a tent,
Correct.
and you were together that entire time.
All the time.
Did Mr. Rosenbaum ever introduce you to someone named Joshua Zeminski?
No,
Did Mr. Rosenbaum ever introduce you to someone named Kelly Zeminski?
no,
Did he ever talk about knowing a Josh or a Kelly?
no,
Do you know Joshua or Kelly Zeminski?
I don't.
How tall was Joseph?
5'3",
How tall are you?
5'3".
And was Joseph a larger individual, build-wise? Was he bigger frame, smaller frame, medium frame?
He was medium, smaller frame.
Do you know, if Joshua had any money on him when he was at your residence?
I'm sorry,
Do you know if he had any money?
Joseph?
Did I say Joshua? I apologize. Did Joseph have any money?
No,
Now, did Joseph spend the night there, or how did he end up leaving? Or what? Let me ask it this way: did Joshua leave? Did Joseph leave?
yes, he did.
About what time?
He left at exactly 9:38 because I looked at my clock,
You looked at your clock.
my watch.
And how was your parting? How did you part ways?
It was really good. We were talking about things we were going to work on in the relationship. He was extremely excited to work on himself, work on some of the things he needed to work on, and he when he left, he said, he said that he would see me in the morning, and he was all excited, and I love you. It was a pleasant visit.
Was there any discussion of the potential for events downtown or the curfew or anything like that?
I did explain to him that things had gotten bad the last few days because he was not in town, and I did tell him explicitly not to go downtown.
And what is the next thing that you remember happening that night in relation to Joseph?
I got a phone call at 4 a.m. from the medical examiner.
And is that when you discovered that Joseph was deceased?
Correct.
Did Joseph own any guns?
No,
Did he have an interest or a hobby involving guns that you're aware of?
not at all.
You never saw him reading magazines or articles or having a knowledge about guns?
No, he did not like guns.
What do you mean?
I'm going to object to this line of questioning based upon the court's prior ruling, motion and eliminate in this subject regarding firearms.
Sustained.
So what did you do once you received this news?
I fell to my knees and cried.
And then what, if anything, did you do?
I went on my phone and looked up on the Facebook Kenosha scanner page to see what the police call might have been about that night. And there was a video link, and I clicked that, and that's when I saw the video of Joe dying.
So you watched one of the videos of the shooting?
Correct.
And that evening, had you been watching, we've heard a lot of people are out there live streaming or filming or the news. Had you been watching any of that?
Nothing.
All right, so you had no idea that anything, you didn't know what was happening in downtown Kenosha until 4 o'clock
Till
in the morning.
4 in the morning.
Once you saw that video, what did you do?
I broke down, and I can't get that image out of my head, so, yeah.
Did you go down to downtown Kenosha at all?
I did the following morning. My sister picked me up about 8 a.m., and we went over to Car Source, and there was the mark where Joe had been laying, and I put my hand in it, and my hand was wet with his blood, and that's, again, when I collapsed on the ground.
I'd like to show you what has been marked as States Exhibits 42 and 43. Put them here, we'll look at it in order, okay?
Okay.
I'd like to show you Exhibit 42. Do you recognize that?
Yes.
And what is that?
It's a picture of Joe and I in front of Quick Trip.
And is that a true and accurate copy of a photo of you two together?
Yes.
If you know, do you know when in relation to August 25th that was taken?
I would say, in relation to when, probably a year prior.
Oh, so probably closer to when you first met.
Yes.
I would like to move Exhibit 42 into evidence.
Objection? I don't. Proceed.
Let's take a look at Exhibit number 43. Do you recognize that?
Yes.
And what is that?
It's a picture of Joe and I in the bathroom.
Okay. And is it a true and accurate copy of a picture of yourself and Mr. Rosenbaum?
It is.
And is that a picture? I'd like to move Exhibit 43 into evidence.
Objection.
I don't have an objection.
Received.
And if you know, where in your relationship was that taken from time-wise? Was it?
This was about April of 2020.
Thank you. I'd like to publish the pictures by having them passed around the jury.
Objection. No. Go ahead.
I believe that's all the questions I have.
Judge, I know you don't want us to approach, but based on our earlier conversation, I'd like to have a conversation about specific areas of inquiry.
Let me ask you folks to step out for a minute. And, yeah, when you finish looking at those pictures, then I'm going to ask you to step into the library for a minute. After you've done so, why don't you step in the library? And I don't think this will be lengthy. Yeah, go ahead. You had to work today instead of your usual leisurely job.
We want you here during the discussion.
I beg your pardon?
Is it okay if she's here during the discussion?
She can step out for a few minutes, but I assume this isn't going to be lengthy. But we'll find out. If you're more comfortable walking around for a little bit, you can, but it's going to be just a matter of minutes, I hope. Mr. Tarathisi.
So Judge, I don't want to, we had talked about this after openings, and I didn't want to step on any pretrial ruling. In the opening statement, there was a statement about Mr. Rosenbaum being in the hospital in Milwaukee. That was addressed with Ms. Ward on direct examination. I am of the opinion that simply stating he was in a hospital is a misrepresentation as to what actually was going on. Most people are at hospitals for physical ailments, to recover from whatever's going on. And I think if we're going to give the jury a clear picture of the hospital he was in, I think we have to be able to at least, I think it's appropriate now based on their questioning, and the questioning is evidence, so that in fact that he had been released from Aurora, their mental health wing, or their mental health.
Why is that not part of the hospital?
I'm not saying it's not part of the hospital, but I think it's reasonable to say that the majority of people believe that you're at a hospital for physical ailments.
I don't know that of course, we get a jaded view because we deal with a larger percentage of people who are hospitalized who are there for mental or emotional disorders. So, but and you're not selling this, sir.
Well, the other area that she had mentioned, or that was talked about on cross-examination was, did he take his medications that day?
Yeah, that's another matter.